So you want extension of time?
Yes, my lord.
Then how it can be done? What is the way of doing it?
My lord.
What is the proper way of doing it?
Matter has been disposed. I need to file a can, my lord.
Yes.
Yes.
Please.
Mention the matter. Give this number. Take the number. Take the single. Tomorrow.
Item number one. Item number one, Mr. Swargar is appearing for the appellant.
My lord, may I
Yes,
be
John.
permitted to appear virtually, my lord?
Yes.
My lord, the matter is my lord, this appeal was filed challenging the order of revocation of probate, which was decided ex parte by the additional district judge at Darjeeling. This appeal was admitted and a trial court record was called for. When the trial court record arrived and we inspected and obtained copies, we found that only the trial court record of additional district judge has arrived, and the trial court record of original probate proceedings, where all my documents are lying and which is very much essential for the proper adjudication of this appeal, has not arrived. So, I am
The records received are incomplete.
yes, my lord.
So is there any procedure in your appellate side rules that once the court has directed, what is the purpose of saying give notice to the appellant when you see it is incomplete? There is nothing you can do in the office for that. An order has to be passed.
My
The
lord,
court has already directed for the
Trial
entire
court
records to
record.
be called. Yes, now if it is not done for some reason,
yes, my lord.
yes.
Without a formal direction, probably the registry will not
But what my
cooperate.
learned friend is saying is that the records of the district judge have arrived. But there are some records which are also lying with me.
No, what he's saying is the records of the ADJ has arrived. The original records
District
are
judge
not.
subsequently transferred the record to the ADJ. Yes.
So whatever the substance is, that record is incomplete.
Yes.
Yes, my lord.
So there is already a direction for requisitioning the record. Then another judicial order is required, or the office should proceed in accordance with law. They should issue a reminder.
But perhaps a special messenger order should be
Because
for your finding of
the delegate court, the district delegate, which is civil the senior division in Siliguri, was not the record of that court was not requisitioned.
Oh. It says trial court record. It does not say any particular court's record.
Yeah.
It includes every record. That includes every record. Therefore, it's to be done. Why the office is not sending a reminder? Why this has to be placed? Or they should put up a report that we have launched.
Yeah, the kind of scrutinizing the record is the requirement. Finds that there is
Take it up post recess. Let us just find out what is happening.
My lord, grateful. My lord.
ये तो दीजिए पूरा ना
Item number 2.
I'm for the state, madam.
This is an appeal, my lord, against conviction. The sentence is, my lord, imprisonment for life.
Life?
Life, my lord. The allegation was under section 302 of the Indian Penal Code. And my lord, the appellant, my lord, allegedly, my lord, the appellant had murdered his mother. Now, my lord, the de
How
facto,
long he has been in custody?
my lord, he has been in custody, my lord, since
From May 2021.
May 2021, almost, my lord, 5 years now.
Yeah.
Yes. My lord, for 5 years now, my lord, almost 5 years, he is in custody now. My lord, look, the de facto complainant is the brother, elder brother of the appellant. My lord, he has filed the complaint stating that the appellant had asked for a sum of money from his mother, sum of rupees 1 lakh. But since the mother could not afford to give the money, but there was scuffling, there was some altercation between the mother and the son. And at night, the son had murdered, the appellant had murdered his mother. And in the morning, the dead body was recovered. Mother. And in the morning, the dead body was recovered. This is the allegation. Now, my lord, the evidence, if, my lord, we scan the evidence, we find there is an admitted dispute between the brothers with respect to an ancestral property that, my lord, the de facto complainant himself has admitted in his cross-examination. My lord, the wife of this appellant, my lord, she is also a witness, prosecution witness. She has supported the prosecution. But from the entire
The appellant.
wife of the appellant has supported the prosecution, saying that yes, on that evening, even I had a fight with my husband. It was so intense that I had to leave the house and I had to go to the house of my brother-in-law. That is the de facto complainant. And I had stayed the night at the house of my brother-in-law. In the morning, when I went back to my house, I found pool of blood in the courtyard. When I went inside, I saw that my mother-in-law was lying dead with a smear on her chest. So, my lord, this is the version of the wife.
Here.
Spear, yes.
There was a spear in the house.
Spear was, yes. And this appellant was not there at that point in time. But, my lord, from the entire depositions, my lord, it is clear.
Circumstantial evidence.
Yes. It was a circumstantial evidence. But there is no eyewitness. My lord, the quantum of money with respect to which, my lord, there was coupling between the mother and the appellant, my lord, that is also in dispute. In one place, the brother says 20,000. In another place, he says 1 lakh. The wife says another amount. And, my lord, from the entire narrative, if we see it in totality, my lord, it comes, my lord, an inference can be drawn that the wife of the appellant was somewhere hostile against him and was in favor of the brother-in-law, that is the de facto complainant. Even, my lord, in the judgment, I have found from the argument led by the defense counsel that there was some illicit relationship between the wife of the appellant and the brother-in-law of the lady. I mean, the elder brother of this appellant. So, my lord, this is the, my lord, version which I have found. My lord, coming to the, my lord, I take your lordship to the PW1 first, page number 14. My lord, PW1 is the elder brother of the appellant and also the de facto complainant. My lord, third paragraph. My lord, he says the day before the alleged incident, accused demanded rupees 1 lakh from my mother. As our mother expressed her incapacity to pay the said amount of money to the accused became very angry and started threatening our mother. At that time, I, along with 2-3 persons, were present. I tried to
Complainant's version.
complainant's version. We tried to pacify the accused. We told the accused that as our mother herself was also a day laborer, so he must understand that it was beyond the capacity of our mother to pay him such a huge amount of money. Then the accused assured us that he would not demand money anymore. Instead, he would try to earn some money by working as a day laborer. Thereafter, we returned to the respective houses. At night, the accused picked up quarrel with his wife, demanding one motorbike from her wife's father. Due to the quarrel and threat given by the accused, his wife came to our house and narrated the same. She put up on the said night with her minor children. In the morning, upon returning home, his wife noticed blood stained on the floor of the veranda at the time of sweeping the house. She had also noticed that the door of the room of her mother was flung open. Then she became afraid and ran to our house and narrated to me the said fact. Then I went there, and entering the room of our mother, I noticed that my mother was lying dead on her bed and with a spear pierced on her chest. Then I started shouting, hearing which many people dropped in at the said place. After some time, police arrived and witnessed the same. Thereafter, they shifted the dead body for postmortem. Before cross-examination, in the same page, before cross-examination, the last line, my lord, on that date, the accused was missing. My lord, let us come to the next page, my lord, page 16. My lord, the second paragraph, after the italics ends, my lord, second paragraph, it is true that I had dispute with the accused over ancestral property. And my lord, next page, page 17. Page 17, it is true that now and then the accused goes other places for work as day laborer. So, my lord, from this version, my lord, it is clear that there was an admitted dispute.
His wife's
PW2, my lord, next. PW2, paragraph 2, the lady says, the day before the alleged incident, the accused demanded rupees 2 lakhs from my mother-in-law. The PW1 says 1 lakh, my lord, she says 2 lakh. And then the same story. Now, my lord, page 19.
Getting my mother-in-law saying. Stop.
Now, my lord, page 19, our cross-examination.
just give us.
Lord.
Neighbor has deposed.
Yes. Neighbor has also deposed. PW9.
PW3 is also. 3 is also neighbor. He has supported.
3 is also neighbor, but my lord, they are not eyewitnesses.
That's all right.
Yes.
It can't be.
Yes. Yes.
Because she says that the mother made a hue and cry, the neighbors came.
Yes, that version is supported by the neighbor. Yes, yes.
By 3 and 9 both.
Yes.
Yes.
My lord, page 19, she further says, page 19, 19. Lord, first para, last line. It is true that my husband and my Bhashur is my lord, brother-in-law, elder brother-in-law, had bitter relationship between them. So the lady, the wife of the accused appellant, also admits that the relationship between the brothers was bitter.
Page 19.
Page 19, my lord, 19. First para, last line, my lord, it is true. So this angle, my lord, is also corroborated by the wife of the appellant. Next, my lord, is the PW3, my lord, the neighbor. The neighbor almost corroborates the fact of the dispute between the mother and
What
the
happened in the evening?
that they do not know. That is hearsay. That portion is hearsay. My lord,
In the evening, this couple was going on.
fight was in the daytime, my lord. My lord, she says, this lady says that in the evening, my lord, kindly see 1, 2, 3, fourth line, fourth paragraph, page 20, fourth paragraph. I have a small grocery shop. Starts from. I have a small grocery shop in front of my house. On that date, Muktabala Bormon, my lord, she is the deceased, came to my shop in the evening at about 6 p.m. and narrated the incident. She was expressing her grief and anguish. She was expressing her inability to meet such demand of
The
rupees.
victim telling her.
Yes. 2 lakhs of his son. She went home and again returned with mobile phone and made a phone call to her elder daughter. After conversation over phone, she asked me to see the time at 7:42 p.m. When I told her the time, then she left home stating she had some unfinished domestic work. On the next morning at 6 a.m., I heard that the accused Biplab committed murder of his mother in the above manner.
And is any other injury on her body apart from this?
No, no.
Stab,
Yes.
only stab.
Yes.
And she's found lying on the floor or
On the bed. Next, Milord PW4. He is the uncle of the accused of the appellant. Milord, he also more or less corroborates the version, Milord, that there was coupling. He had heard accused had demanded money and all those things, Milord. But PW5 is a Caesar witness, Roman Bormon. Milord, he says that the police seized the mosquito net, blood-stained earth, and bed cover in my presence. So he
For the state, my lord.
May I, my lord? My lord, this is a case under section 302 of the Indian Penal Code, my lord. If your lordship sees, my lord, there is a paper book, my lord. If your lordship sees the paper book, my lord. The whole case is based on a circumstantial evidence. The prosecution has tried to bring the conviction based on extrajudicial confession and last.
In the earlier case, the paper book was. The earlier case, the paper book is already prepared. Someone to get the learned advocate who was just now arguing the earlier.
Arjun Chaudhary. Taken here.
You can direct for listing of the matter for consideration of appeal.
May I, my lord?
Yes.
On two grounds, my lord. Extrajudicial confession. Another is last seen together theory. This case is based on, my lord. Now, if your lordship sees the FIR, my lord, the FIR states that the accused person was married to the deceased, and the FIR writer is the.
Paper book has already been prepared.
Yes, my
I think
lord.
the appeal should be heard.
Yes, my lord. I have no problem, my lord. Paper book is ready, my lord. I am also ready with the case, my lord. But it will take time, my lord.
No,
It's better to reject.
Next week.
To consider the bail, my
let
lord.
us start today, my lord. Otherwise, it will be difficult to complete. My lord. Next week, we have only 3 days. And Friday, probably the last day next week. Very difficult. Because our officers all will be in hurry to go.
No, that's not the point. Nobody will be in a hurry. The point is, it requires consideration.
Yes.
Therefore, it is going to be in a hurry.
We are ready, my lord.
We were just thinking that we'll direct for expediting the appeal. In the next circuit, it can be placed. In the earlier
My lord, you are ready.
of that paper, we could prepare
Paper book prepared.
and serve.
Because once the paper book is prepared and we go for bail application hearing, we already go all through the evidence and all. So, otherwise.
Are able to respect to take up the matter for its final disposal. So, the hearing be expedited in the next.
What should I do, my lord?
How much time you will take?
I'll take time, my lord. It's quite a lengthy case, my lord. If I have to do the argument, my
Because
lord.
his lordship is correct. If the paper book is prepared, then why not it should be expedited?
As your lordship, please, I have no problem. It's a legal aid case, man. And I do not know how, whether he got bail during the trial.
My lord, this is
Usually,
I think it's a POPSO case.
no,
and
not POCSO,
this one-
302 case. And it's
Saying 302.
three.
minor witness is there, fully corroborating.
No,
the
no,
other
not at
witness.
all. I will show 164 not corroborated in the deposition. She was totally tutored.
Yes, that-
The case first began with extrajudicial confession, then led to last seen together theory, which was not. It's a very good case. I can say,
Good and very easy both.
my lord. It's a very good case.
for-
He's on bail or
खूब भालो
he
case
got
है.
bail. Accused got bail or not?
That I don't know. It's a legal aid matter, my lord. I do not have any assistance from that side, my lord. I have just gone through the paper book, my lord.
The record should show if he's on.
My lord, the record doesn't show whether he is on bail, my lord, because the order sheet will show, my lord, and all the order
That's
sheets,
what we are saying, the order sheet.
my lord.
Not he is, I
That
don't
is
think
not
he is
there.
on bail, because had it been on bail, my lord, he would have engaged someone from, not a lawyer from the legal aid. He is inside.
That I
He is
don't
in
know,
the
my
jail
lord.
custody.
Might be, my lord, he doesn't have financial support, my lord, that's why. But this is a good case.
The case of the year 2016.
Huh?
It was started in the.
Yes, ma'am.
Hmm.
No, he is not on. There are 4 dates altogether prior to today.
Yes, my lord.
Today was that appellant say for suspension liberty. The second date is in February. But he is not represented.
Thereafter, the legal aid was it.
PW 9. 9. PW 9, my lord.
No, sir, it's completely clear.
না, বিলে নাই।
বেলে না থাকবে। আগে মানে ট্রায়ালের সময় বেলে ছিল কিনা?
So there is no bail.
No, during the trial, whether he is on bail, that is to be required to be seen from the lower court's record. My lord, it will not come away. That I don't know, my lord.
Trial court record. Definitely, trial court record is there. Paper book is prepared already.
No, it will be in the judgment. If he is on bail in the order.
No,
itself,
no.
Sometimes
it
It will be taken into custody.
will be taken into custody on the
The
first day.
bottom of the order, it will be there. For production and if upon conviction, he has to be produced for sentencing hearing, hearing on the point of sentence. So. Guilty. He was on bail, my lord. The bail bond is cancelled and the accused is taken into custody.
He was on bail.
The matter at that stage only.
My lord?
Immediately after conviction, it was assigned to the legal aid.
My lord, I think he gave an application to file the appeal, and thereafter the legal aid filed the appeal, my lord.
Jail appeal.
Jail appeal.
These are jail appeals.
Jail.
One page
But he
memo
was
of
on
appeal
bail,
from
my
the
lord.
jail
That
that
much I can
comes.
say.
One page memo of appeal comes from the jail.
When to have it, Monday or Thursday?
Well, as your lordship, Monday is a strike, my lord. I do not know, my lord.
There is a possibility.
You
my
seem
lord.
to be knowing. You say you do not know.
I don't
Monday,
know,
maybe
there's a
fixed on
notification
Monday,
in the High Court, I think so. They have called for a strike. Cease work, yeah,
Why?
because there's not adequate judges in the High Court. For that reason, they have called for
We
a
are
strike.
In numbers, my lord.
It's Monday.
Based on Monday.
My lord,
For consideration of the appeal list on Monday, the date of Monday.
my lord, it will be kept on Thursday. Monday or Thursday, my lord.
No, let's see.
Monday. As your lordship. Grateful, my lord.
Item number 4, we don't want to take it up too late in the next week. If we take it up too late.
It will not take much time. One or two important witnesses, circumstances.
No, she's saying
Grateful.
Oh, I don't know.
So this is your case, the one we took up yesterday.
No, Lordship, in this case, I am for the appealant. So the facts of the case, I have already placed before the Lordship.
That's what we are saying. We took it up yesterday.
Yes.
My lord had put some questions to me yesterday. My lord, with respect to that, my lord, I've gone through the entire case files. Now, my lord, what I found, Lord, the motive is stealing money because he was in urgent need of money. Lord, I'll come to the concerned evidences, why, how it has been established. Second, my lord, how did he went inside and how did he commit the crime? Now, my lord, PW4, Dinesh Guru, he was the eyewitness of witnessing the fact that he went inside the house. He categorically says in paragraph 4 that then I saw Pranesh Rai opening the lock. He was the nephew of the deceased lady and entering into the house of brother Novin. At about 12 or 1 o'clock, I came back home and got the message that my sister-in-law, Chitrakala, had been murdered. So, my lord, the
He saw this man entering the house,
yes, opening the lock and entering the house.
opening the gate,
Gate.
locking the gate and
Yes.
entering the house.
Yes. Now, my lord, after he comes out, my lord, in the CCTV footage, it was seen that he was wearing a green color vest. That green color vest, my lord, was later seized by the police personnel. It was placed before a test identification parade before the learned judicial magistrate. My lord, that vest belonged to the husband of the deceased lady. So he went there. He had identified the vest before the judicial magistrate, and he has also deposed the same before the magistrate. That vest was exhibited, my lord, in the trial. So, my lord, his presence in the house and his my lord, taking the vest of the husband of the deceased, my lord, is established by cogent evidence. My lord, next come the motive. My lord, money was stolen. My lord, he went
This vest belonged to the victim.
victim's husband.
Acha, wait up. Here. And it is alleged that he took it away.
Yes. Since there was blood in his own t-shirt, my lord, he changed it. He wore the vest of the.
So his blood stained t-shirt is found at the place of.
No. My lord, he disposed it off.
And anything missing from the house?
Gold chain was missing, my lord.
1 lakh rupees.
Huh?
1 lakh.
1 lakh rupees of cash and gold chain was missing. But subsequently, after he went,
But if we remember correctly, he has deposed that the person who came out was wearing a blue mask and a grey cap.
no, my lord, in the CCTV footage, my lord, it was seen that he was wearing a green color vest.
My lord, in this case,
Green color vest and mask can go together. Not that if he is wearing a green color vest, he will not wear a mask.
Yes.
So if he is wearing a blue color mask, this is a question we asked you yesterday, how he has identified this person? He is the only one who saw him enter. Did he see him come out?
No. No.
No. As far as we remember, he did not see him come out. He saw him go in. And he saw him wearing a blue mask and a grey cap. So how he has identified?
But, my lord, from the CCTV footage, my lord, he was a suspect. He was later apprehended. This vest was recovered from his custody.
Why he was a suspect? What links him?
My lord, from the structure, body structure, my lord, he was a suspect. From the body structure, my lord, even if
in the CCTV image.
yes, even if he is wearing a mask, my lord, his face is half my lord, closed. The rest of the portion of the face is open. So from the entire body structure, from the remaining part of the face, my lord, he was a suspect. And later, when police apprehended him, my lord, these things was recovered from his custody. And the same has been identified by them.
How the police reached this person, that we are trying to understand. See, somebody saw him going. That time he was wearing mask. When he came out, the face be seen in the CCTV image.
Coming out was not seen, but he was loitering there. He was present there, my lord. It was.
That was found in the CCTV that he was in the locality.
Yes.
So there was no CCTV at the house from where he is coming out.
No.
It was something else outside the premise.
Yes.
So therefore, there may be so many people loitering around. Why?
But my lord, he must have taken some other route of coming out, because the coming out of from the same gate was not seen in the CCTV footage. So he must have adopted other way of coming out of the house.
So is there anything to show that there was a window broken or open on some other sides?
No. Neither. But leading to recovery was from him. Since it has been identified by the husband that this particular cloth belongs to me, then this burden shifts upon him. How come his brother's cloth was with him? He has to explain under 106 of the Indian Evidence Act. That explanation is nowhere now.
But any garment that he has can be said that it is mine and he has taken it.
No, but it was not the single one, Lord. In the TIP, there are number of similar kind of clothes were placed before him, and he had identified only the same Lord which was his. And Lord, after he went to his friend's house, the other yes, the friends, Lord, one of the friend had deposed that in the morning, Pranesh told me that he is going to get money. After he comes, he returns back, Milord, he gives me a sum of rupees.
See, how many PWs are there?
Milord, 44.
45.
45, sir.
45 examine, my lord. My lord, in this case, equally, there is no eyewitness in this case. Only PW4, Dinesh Guru. On the relevant day, he saw that appellant was loitering at the PO. And my lorded PP stated that on the relevant day, this appellant had a gray cap on his head
Yes.
and blue marks. But it is found in the CCTV, my lord, that unknown person wearing a black cap and white marks. It is the PW16, Nagendra Rathi, deposed in the cross-examination.
Who is he?
He is a PW16, Nagendra Rathi.
Who is he means he is a neighbor. He is
Neighbor, yes, my lord.
officer. What is
No,
it?
neighbor. He's a neighbor.
So his CCTV has captured this
Yes,
image.
yes, because his house is just nearby.
So he
This-
says he
this is-
was wearing a black mask,
Black marks. No.
White-
Black cap and white marks.
white mask and black.
Yes, it is found in the CCTV.
Also green t-shirt.
And PW4 said blue mask and grey cap.
Yes, he had a gray cap and blue marks. But in CCTV, it is found black cap and white marks.
And that green t-shirt,
Yes,
that is consistent.
yes, my lord. And my lord, in this case, I have already submitted my deposition to court, my lord. So in this case, my lord, PW4, Dinesh Guru, deposed in para 16 in cross-examination. He deposed that I have no personal knowledge as to who committed murder.
As there is no, he is not the witness to the incident. That's why he
Yes,
said,
yes, my lord.
how can he
Yes,
say?
yes, my lord. He himself stated in cross-examination in para 16. I have no personal knowledge as to who committed murder.
Now, Milord, this is
I have already submitted the process. It is in the para 16, my lord. PW4.
PW4.
Yes, my lord. Para 16. Cross-examination line.
There is a difference in color of the marks and the cap.
Milord, that is that.
PW4 said one thing and PW16 or something.
Milord, in
That
CCTV,
is the-
Milord, this is a very trivial.
Now, my lord, in this case, the doctor deposed in para 12 and 30.
That seems to be gray or something like that.
Well, I'll
Before something like that.
But one thing I
And
just
my
would
lord,
indicate,
one point is there.
Can we read for a minute? Can we read for a minute?
As per evidence of PW4 that he saw that the accused, as per evidence of PW4, he saw that the accused entered into the house.
No, actually, Lordship, in this case, PW4 stated that that appellant was entering inside the house of deceased. But PW1, Nabin Guru, the de facto complainant deposed that when I reached my house, that time my house was locked. And I opened the house with the duplicate keys.
You can open the lock, but you can also close the lock.
And on the moreover, my lord, in this case,
It is not that he broke the lock, he opened the lock.
my lord, PO is a very busy place. It's already stated by the IU.
How can it be disbelieved in terms of the testimony of PW4? How can it be disbelieved? That he, how can it be disbelieved? The
No,
evidence
no,
of
actually-
PW4 that he saw the.
No,
accused
PW4 is not the eyewitness. Who saw?
Simply there is no eyewitness.
Yes, yes. Who saw that this appellant committed murder to deceased? He saw only that some unknown person. Later on, he came to know it was appellant.
The
First he said that- first he
entire
said
case
that-
depends upon the circumstantial evidence. There is no question of witness to the incident.
Yes. But he himself stated that who committed murder, I can't say.
No, apart from that, he says, I cannot identify you. Not
Yes,
only
madam.
is he saying.
And on in CCTV camera, the mask and cap is found
But
it's
there is
different.
no conviction based on such
Yes.
identification. See,
he could identify me, Lord. He says that.
that is subsequently, because what, according to them, what completed the chain of circumstances, recovery of the T-shirt. Because to that extent, there is some consistent evidence that he was wearing a green T-shirt. That T-shirt belongs to the victim's husband, and he has identified it. So section 27, they will be relying on.
106 of the evidence act.
No, because that recovery.
Recovery 27, my lord. Yes.
27
Yes,
also
yes.
you'll be relying
Yes.
on, not only 106.
Yes, yes.
These inconsistencies, it may have mattered, it may matter if there is a conviction based on a deposition that yes, I have seen this man do it. He is only seen in the locality. Any article which was said to be stolen has also been recovered from it. The chain and the cash. No. And how many days after the incident he was arrested? somewhere we saw that perhaps he's a student or. Yesterday we.
You are the student.
There is a seizure. There is a seizure list.
The offending weapon, my lord, in this case,
No, where is the seizure list?
yes.
It is the.
No, I have already submitted that.
Yes, you were saying.
Yes, yes. The offending weapon that it is, doctor deposed in cross-examination in 12, line 12 and 13. Injury may be caused due to sharp cutting weapon, but MO, metal, this exhibit, not sharp cutting weapon, but it is blunt object.
What weapon was recovered?
Blunt object, is hammer.
Hammer is recovered.
Hammer, blunt object, is like a.
No, no, what, any weapon was seized.
No.
Where is the seizure list? That has to do.
Yes, to annex similar to, yes, not annex. Not be able to similar to. Yes, not annex this. Yes, not annex.
Seizure was done.
Must have been.
It must
Because the
have been
green
done.
T-shirt is there, then we don't know whether any other article was recovered, whether the alleged weapon was recovered. Where is the seizure list?
It was a masher. Masher. It was seized from the river, Rangit River, on the basis of his leading set.
And
On the basis of his statement.
Leading set.
and my lord,
Recovery of fallen.
Mason. Oh,
In the river, so there must not be any stain or any. Yes, if it was in the river, there can be no blood stains. But he has said that it is there.
Yes.
And that has led to the river. So mostly found on section 27.
Yes. The incident happened on 14th March and he was arrested on 16th. So.
Yes.
and in cross-examination, my lord, in this case, phase 2, the Nabin Gurung, this complainant, de facto complainant, deposed that there are my signature in complaint dated 28/3/2022. And signature are shown to the witness and identify the witness. No, my lord, in this case, PW1, Nabin Gurung, deposed in cross-examination in phase 2, my lord. These are my signature on written complaint dated 28/3/2022. Phase 2.
Phase 2 of this compilation.
Yes, phase 2, yes. Phase 2,
Phase 2 is FIR.
no, not FIR, deposition. Deposition.
PW1.
PW1.
Case two in which portion?
Page two, my lord.
This one.
Page two, report. Top line, top.
You have given us is not legible. You cannot give it.
What I understood from his submission, it is written, these are my signatures on the written complaint dated 28/3/2022, signature shown to the witness and declared by the witness. Now, my lord, he is trying to establish that the FIR was made on 28. My lord, this is a typographical error. The documents, the FIR, everything shows it was on 14. Just, my lord, while typing the deposition, my lord, it has become.
How it can be on 28 because
Yes.
arrested on 16.
Yes.
But one thing is there, my lord. This, the signature are shown to me.
All right, but there is no dispute that he was arrested on 16th. The FIR would not be lost 12 days thereafter. There is a documentation that he is arrested in connection with this case. That is hardly relevant.
It has already been marked as exhibit. Document is there.
And document is marked as exhibit.
Document is there.
That's
Document
not
is
an
speak for
issue,
itself.
but then it's not legible what you are showing us. Yes.
The PW8, Lord, I'll conclude, not just PW8, if your lordship is having the page 14 of the compilation, Lord, yes,
Paperwork has not been prepared.
not yet,
There is a direction in the last year in the month of August.
but not yet.
The paperwork
prepared,
is
as per
just
this.
And anything about his academic pursuits? What kind of student he was, where he is studying? Because somewhere we saw yesterday that he is a student.
PW8 was a student of the Government College Darjeeling. And PW8, and he was the roommate of this appellant.
He has been examined.
He has been examined. PW8, page 14 of the compilation. Lord, yes. But he says, have your lordship found it? Lord? Aditya Rai, PW8. On his legs before the division.
So no question has been put to him regarding his educational inclination or disinclination. And these other persons who he is referring to, Evangel and the sister, they have been examined also.
Yes, Evangelist PW7. She is also first year student. Lord. Just one page before, page 30.
Anything else?
No, sir, that's it.
Art learned advocate for the appellant and the state. This instant appeal has been preferred, challenging the impeachment and conviction passed by the learned trial court.
Item number 5.
My lord, I am for the appellant.
It's defective.
My lord?
It is defective.
No, my lord. Delay. That is a defective.
So it is defective. You filed an application.
Yes, my lord.
Can number?
Can 1, my lord. There is a delay of 372 days. The victim has to be notified, my lord. This is POCSO case. Yes, my lord. We have already sent and it has returned, my lord. Deeply aware.
So in this matter, I am led by Mr. Shah. He's appearing online.
Yes.
Yes, Lordship. Lordship, this in this matter, Lordship, pursuant to the earlier direction passed by the learned this bench. Lordship, an exception was directed to be prepared by the appellant. Lordship, we have prepared the exception. Lordship, that is the affirmation is going on today. Lordship, we have prepared the exception.
Item 7.
Yes, item 7. So there was the earlier direction on 11th of February 2026. We have prepared we have prepared a exception to that.
When you will file it?
By
When will
today,
you file it?
by today itself, it will be prepared.
We are informed that exception will be filed during course of the day upon due service, after due service upon the learned state advocate full stop. Only state or corporation is also part.
No, only state.
Full stop. Let the same be done during course of the day. List. Tomorrow we can, or Monday. Give a copy. Monday. Give the date.
Obliged, Your Lordship.
Obliged.
Item number 8.
Lordship, I am for the appellant. Trying for next circuit, Your Lordship.
Why, sir?
Your Lordship, the matter was about to be listed on 16th of the circuit, but somehow it appeared today.
We upon 6th, it was fixed for today.
Your Lordship, we followed the e-code service. It was showing a 16th till yesterday.
6th, you have appeared.
Yes, Your Lordship.
You were told that it will appear on 9th. How you are saying it will appear on 16th? Who are you? What is your name?
I'm the appellant. I'm
What is your name? There are 4 lawyers who appeared for appellant on 6th.
Sujit Swami, Your Lordship.
So you are here.
Yes,
You
sir.
know that it was to be taken up today. What you are saying it will come on 16th? On sixth, we have passed an order that it will come on 9th.
We prayed that the matter is to be listed on 16th. The court allowed, but somehow in order, today we saw the list that the matter is appearing today. Your Lordship. On that day, we prayed for the 16th. The court also allowed this.
Sorry, we'll go by the order sheet. We will go by the order sheet. This is not a way to. What is it? Let us see. Don't make such submission that are wrong. You could have told us on 7th. Why did you not mention yesterday?
Till yesterday, it was showing 16th, Your Lordship, in e-courts.
Yes. Saying that it doesn't seem. Must have said Thursday. Was in Friday. Not that we can, but I think Thursday. In this Thursday. Already we are keeping it on 16. As paid list on 16.
Deep your back.
No. No other. No, has to be as paid, yes. We have said as paid list first.
Item number 10.
Yes.
আপনারে বাবা পরেরটা লিখুন
প্যাকিং বাক্সের মধ্যে কোথায় গিয়ে বসে আছে? এক গাদা প্যাকিং বাক্সের মধ্যে বসে আছে কি? Packing বাক্সের মধ্যে- কি? প্যাকিং বাক্সের মধ্যে প্যাক করে পাঠিয়ে দিন। কে? ওই বুড়োটা? ওই বুড়োটা বহুত জ্বালায়। উচিত তো তাই। কুশল ঠিকই বলছে, যারা আসবে না তাদের মামলা করা হবে না, যারা আসবে তারা করবে। ভার্চুয়ালি বসে থাকবো। Yes, Lordship. My Lord, if my Lord give me a couple of minutes to give you Lordship the background. My Lord, petition appellant's father was running took a land on tenancy in the year 1964. He built a hotel there.
How he acquired the land?
Initially as a tenant. Now, in the year, this was in the year 64-63, my lords. In the year 1975, like that, there was an agreement of sale, that property to the appellant's father. The sale did not materialize. There was a suit for specific purpose of contract. Appellant's father lost it. There was an appeal carried to the High Court. The matter rested there. Now, since 1975, the appellant's father did not pay any rent to the trustworthy landlord did not take any action whatsoever. Possession till the night of 2023, a fire destroyed a majority portion of the building. No matter after the building was destroyed, that was the only livelihood of the appellant. Appellant intimated the corporation that I want to rebuild. My lord, I frankly admit the appellant ought to have waited for the green signal. He only put a tin shed. The original structure that was there since 1963 had a tin shed. No walls have been erected, nothing. Because he is running a temporary hotel on that premises, so he just put a tin shed. After the tin shed was constructed, my lord, the added respondents, brothers instituted a suit before the civil court on the ground that appellant cannot build without the sanction of the corporation. Corporation took cognizance of that.
Instituted a suit.
Yes, title suit. And the appellant is contesting. Appellant has taken a plea of adverse possessions because in the year 1999, there was a rent control action in which the added respondents co-sharers went and gave in writing before the court that appellant is an illegal occupier in the year 1999, and the appellant has taken a plea of adverse possession along with the written statement. In the interim, the civil court injuncted the property. Appellant cannot build. Whatever he has built, only the tin shed that is there, and now no further construction. So, my lord, my submission is that in view of the injunction, temporary injunction granted by the competent court of civil judicature, nothing can be done on that property. Any subsequent notice or notice relating to the property by any other authority except the civil court is redundant. And my lord, if I am evicted by breaking down that tin shed, it may be irregular, my lord, but not illegal, because corporation very recently has renewed the trade license of the appellant on that property. My lord, we have the trade license. My lord, can just
What is the date of temporary injunction?
Temporary injunction was granted in the year 25.
Date.
My lord, I have to just give me a couple of. CS karo. My lord, this is the last date of renewal. My lord, I will file it properly. On 7th May 2026, the trade license of the
This is on
appellant.
record.
No, my lord, it was on 7th May.
Very well. Let's just.
So, my lord, my first prayer in the writ petition before the writ.
What
court-
is the title suit number and date of temporary?
My
injunction?
lord, it is 85, I think.
You have copy of the order. Is a copy of the order on record?
My lord, yes, we have a file.
Where is it?
My lord, will find the lower court pleadings in page 170 onwards. Supplementary was not supplementary. Supplementary. So, तुम्हारे भी नहीं है ना? It is addendum in the temporary case.
23/3/23.
My lord, it is the addendum one. My lord.
23/3/23.
Yes, my lord, it is addendum, and subsequently that was made
That was
temporary.
confirmed.
Confirmed.
When?
My lord, I will just give you lordship the date. अरे third तारीख हम बोलते हैं temporary.
How this order comes to your aid in the,
Which one,
before
my
the
lord?
corporation?
My lord,
How this order comes to your aid before the corporation?
no, my lord, my business right to carry on business has not been touched by the trial court. Only that I cannot construct. Now, if whatever construction is left over there, if that is dismantled, I will be evicted, my lord. I will be left with no shelter.
It does not say that any structure is existing and it is to be
No,
maintained.
that has been settled. My lord. Structure is there because Red Court has said, instructed the corporation to find from its own record two things: whether there was any existing structure and whether there was any plan with the corporation. In the first count, corporation admitted yes, there was an existing structure.
What is the relief sought for?
But not only the thing, the main relief that was there, that I be allowed to continue my
Where is the
business.
prayer in your writ petition?
My lord,
Which page?
a writ and or order or orders in direction or direct nature of mandamus directing respondent number to allow the petitioner to start the pie hotel of the petition. Prayer, my lord. Lord, you will find at page 31 of the canopy.
You have annexed it.
Yes.
And where is this notice of 6/1/25?
(6/125), my lord, at page 87 of the here.
Yes, and where is the West Bengal Municipal Corporation Act 287?
West Bengal Municipal Corporation. Bengal Municipal.
Mr. Pal, can you provide a copy? Mr. Pal is there, but he will supply a copy.
I'm providing.
Second batch ke dao.
Yes, so what is wrong with the order? Tell us.
My lord, the thing is this, as of 7th of March, Respondent Corporation has renewed my license in signifying that I can carry on business. My lord, the only wrong that was committed by the appellant was he
License is granted under which provision? Huh?
Rule 140. Section 141. West Bengal Municipal Corporation Act,
141 or 142?
141.
The Corporation Council is saying 142.
But the notice contains 141.
41. Certificate for enlistment of profession, trade and calling.
It's a provisional investment or?
Final estimate. No, October ko bhi ko. No.
How many it is for? What is the validity period of the?
But it's for on 1 year.
Then it is provisional, then it is not a
No,
permanent.
my lord, it is renewed yearly. Every year it is.
Provisional is renewed for a year, permanent is for 3 years. That is what 141 says. 141(3) deals with permanent.
My lord, it is up to 29.
Huh?
Up to March 29. It shall take certificate will be forced until 7th March 2029. It was issued. Act will done.
So that means how many years?
3 years.
You said 1 year.
My lord, I did not notice.
Then yeah, anyway, so even if it is a permanent, what difference does it make?
No, my lord.
How it helps you, that we are trying to
answer.
understand.
My lord, the corporation's grievance is against the construction. Private respondents complaints against construction. Nobody complains against my, that I am not in possession or there was not a structure.
That's not the issue before the municipal authorities.
My lord.
That is pending in the suit. See, there are
So,
two
my lord,
issues.
my first
One is regarding your possession and your right to possess, which is subject to the civil code. Civil code says injunction, whatever you do it with permission of the authority. You go for permission to the authority says, how can we permit? There is no plan. That is the
My
issue.
lord, now,
So what is wrong with the order
now,
we
my
are
lord,
asking you?
we have submitted a blueprint plan.
So
corporation-
pursue it.
No, my
Who
lord,
is stopping you?
corporation says, without you being the owner, we cannot grant.
No, that they have not said.
Yes, my
Please show from the order where it says that because you are not the owner, we will not give you the sanction.
Last order টা কোথায়? Corporation order. One
57.
page mark করো না, ভাই। Wow.
57.
ঠিক দাঁড়াও না। এরপরে 8 পেজের No, my lord, it is not there.
We have seen, therefore we said, there is no, it can't say.
No, my lord,
You may proceed, the single judge has given you an liberty to.
No,
pursue
we
the-
have done that, my lord.
Then
Now,
you
my
pursue
lord,
it, then what is to be
my
done in that?
predicament is this, my lord. If during the pendency of the civil suit, what was my main arm of prayer was, without claiming any equity whatsoever, I be allowed to carry on my business.
So the municipal corporation should vary the injunction.
No, I am not constructing, I am prevented from construction.
Yeah, there's nothing here. You have to get a sanction that without a prior plan, you cannot be allowed to construct.
My lord, I am not constructing.
You
I-
cannot maintain anything on that property unless you show a sanction plan.
My lord, there was my structure which got gutted.
But that is admittedly, it was gone in the fire. There is no dispute.
No, not
Even
that.
if it has existed prior to there too, even if there was a legal, illegal, whatever structure, it was lost in the fire. So therefore, now whether you can construct or not, that
My
is
lord,
the only issue.
I am not praying for any regulation of construction before this court, my lord. My
No,
thing,
but you want this order to be set aside.
only to the
What you have gone to the commissioner for?
for regulation of my plan.
No, sir. Where is that application? Show us.
No, the last after the
Show the application which led to passing of the impugned order, what it is for. Whatever it is, there is no plan, it cannot be regularized. In fact, you have been given liberty, if you are pursuing it, you may pursue,
My lord,
it. They will
we-
proceed in
we-
accordance
We
with
did
law.
not annex it with the appeal, but if my lordship permit.
Not
me-
required, not required, that hardly makes a difference.
No,
That does not make any difference. We are asking you what is wrong with the commissioner's order or the tribunal's or
no, my
the
lord,
authority's order.
I have only prayed for that I be allowed to possess the property till the civil court comes to a decision. Now,
Who's-
my
How the commissioner can say this?
commissioner will not say this, my lord. I have not.
Then why are you here? That's what we are saying.
Commissioner has asked me to dismantle the tin.
Correct, correct.
Rightly, my lord.
That
But
rightly.
if that
rightly
is
so.
gone,
Yes.
I be left in the open. Rightly or wrongly, my lord, it has been constructed.
That is the whole point. The corporation is the authority to see whether it was done rightly.
No, my lord, let us
If it
assume
is
it was
not done rightly, it has to be removed. See, even if you are the owner of the property and there is no dispute about the land, the structure can still be torn down if it is not in accordance with law. Where's the question of the two different things?
My lord, they are not
You are
saying
trying
it is
unnecessarily
illegal.
to
They
integrate.
have never said it is illegal. They have said it is irregular.
No, they say it is illegal. There is no sanction plan. 287, you cannot do it unless there is a sanction.
Then,
It
my
is
lord,
illegal. There is no
my
question
lord,
of
I have
irregularity.
I may be permitted to withdraw the appeal, let the commissioner decide my application.
Yes.
Then I can come back.
The learned advocate for the appellant.
No, I did not troubling a lordship. I am not
Yes,
troubling a
we have-
lordship.
we have
Lordship
seen
is
you.
Absolute. Yes,
We have seen
that's
you,
enough.
yes.
That's enough for me.
The learned advocate for the appellant does not wish to press the appeal to pursue the remedies in terms of the liberty granted by the honorable single judge. Appeal is accordingly disposed.
Only my grievance was, my lord, equity was not considered by the court.
Yes, call it.
দিও না তো, দেবে না তো।
Yes, sir. I am the appellant. I led by Mr. Senior Advocate Mainak Bose.
Yes.
He's on virtual models.
Yes.
My lord.
My lord, I am for CGST, my junior is there.
You are for?
I am for CGST authority, my lord. That is responded.
CGST.
CGST authority. My lord, the challenge in the appeal is against an order by which my writ petition was disposed of with certain directions. My lord, what we challenge in the writ proceeding is an order which was passed, my lord, under section 129 of the CGST Act, my lord, by which penalty was imposed. My lord, if I may just briefly tell your lordship the facts, my lord, and the impugned order in fact has complicated the entire writ petition, which was based on, my lord, two division bench orders of our High Court. My lord, we relied upon those in the writ petition. My lord, what has happened is, my lord, Erica nuts, my lord, beetle nuts, which are commonly known as Erica nuts, my lord, was being transported by us, my lord, from Guwahati to Delhi. My lord, the vehicle was intercepted on 2nd of July at Jalpaiguri. At the time when the vehicle was intercepted, the vehicle was admittedly carrying tax invoice, e-way bill and transport challan, the documents which are required to be carried for the purpose of transportation. All valid documents, well, there is a provision under section 138, rule 138A, this was being carried. So there was an interception, and based on an interception, a physical verification was made, and subsequently a show cause notice was issued. Now, my lord, in the show cause notice, my lord, this is in substance, I'll tell you, lordship, before I take your lordship to the details. A show cause notice was issued proposing penalty under section 129A and 129B. My lord, I am the owner of the goods. So, my lord, as an owner of the goods, my lord, I also gave my reply to the show cause notice. And, my lord, the principal ground on which the show cause notice was issued was, my lord, valuation. This was the principal ground on which the show cause notice was issued. My lord, valuation in the sense, my lord, undervaluation.
What is the date of the show cause notice?
well, the date of the show cause notice, which will be at the 15th of July 2025,
Yes.
which is in the
Yes, please
prescribed form,
continue.
which is MO. Now, my lord, they say the principal ground on which the show cause was issued is undervaluation, that the goods were allegedly undervalued. So, my lord, undervaluation is not a ground available to the authority for the purpose of detention or interception of the goods or for seizure for that may. So you have to take steps under section 73 and 74 of the act. Well, that's why in the reply we refer to a judgment of the Allahabad High Court passed by Justice Saraf, indicating that this comes within the purview of section 73 and not under 129. Be that as it may, my lord. Thereafter, on the basis of the representation we made, my lord, they exercise their power under 129 and they pass a penalty order. Now, this penalty order was under challenge in the writ proceeding. One of the principal ground is that the authorities did not have the jurisdiction, my lord, to pass the or to intercept and pass the order of seizure, because none of the grounds available under 129 was either mentioned in the show cause notice or in the previous physical verification, on the basis of which summons were issued.
Penalty under 129.
And my lord, so far as the penalty is concerned, my lord, 129A and B, 129A relates to owner. Now, my lord, I as the owner, my lord, I am claiming the, my lord, the ownership of the goods based on the tax invoice. So, my lord, there is a circular of the authorities, my lord, a circular issued by the prescribed authority, which says that if the goods is accompanied by a tax invoice or a e-invoice, which is in the name of the owner, then the person whose names appears in the e-invoice should be considered to the deemed owner. So, my lord, if I claim to be the owner and nobody else, my lord, controverts the claim that I am the owner, my lord, so I should be considered to be the owner. So, my lord, the penalty imposed is under 129(1)(a) because I am the owner. So I was ready and willing to pay the penalty and take release of the goods, because these goods have a shelf life. My lord, these are perishable goods, and my lord, subject to that, we said that we will challenge the remaining portion of the order. So this was the scope of the writ petition. And my lord, while considering the writ petition, my lord, we relied upon two division bench orders of this honorable court, that in a situation of this, writ petition is maintainable and I am entitled to release an interim order. I am entitled to release based on the penalty which has been computed by the authority. I am entitled to release of the goods as the owner under 129(1)(a). Now, my lord, one of the division bench judgments of the Calcutta High Court, well, the previous Chief Justice's judgment, went up in appeal before the Honorable Supreme Court. My lord, Supreme Court initially had passed an interim order to ascertain, my lord, why the goods are not being released. And thereafter, my lord, based on that interim order, certain directions were given and affidavits were filed, required to be called for. And thereafter, the session list petition was dismissed. My lord, the honorable judge, instead of looking into the two division bench orders, looked into the interim order passed by the Supreme Court, and based on the single bench's order, which was set aside by the division bench, my lord, passed the impugned order directing us to go before the authorities. So this is what is under challenge before your lordship, my lord. My lord, may I just say this, my lord? The impugned order has made the issue very complicated. So what I was respectfully submitting, my lord, if your lordship gives me this indulgence, we would like to come down physically and do the matter. If your lordship keeps the matter on Monday, we would like to be there physically and do the matter.
Very
If
well.
that is, well,
Yes. As prayed, list on, give the date of Monday.
My lordship, small indulgence.
Yes, please.
Yes.
My lordship, the morning with the matter which I was mentioning is similar to this matter, and I have also filed a can. There was a mistake of fact. The can has already been filed. If you could
Mentioning time, are you mention at the mentioning time? Not like this.
oblige, my lord.
Monday.
Grateful.
Item number 12.
Item number 12, I am for the applicant. We have filed a application CAN 7 under order 41 rule 27 for real problem. Oh, sorry. No, my 40. Mistake here.
My lord, I'm for the appellant. I want to not pay this one. May I appreciate?
Yes. Does not wish to press this application. Appeal is dismissed.
Item number 14.
I am for the private respondent. Kindly give a 1 week time. We want to file the opposition. If there is an opposition.
Already filed.
We will file, my lord, in this week, my lord.
You are for the sole respondent.
Yes, my lord. Sole respondent, husband. I am a wife.
The learned advocate for the respondent seeks time to file an opposition. There is an application or appeal?
Application.
To the application.
Can 7, man. Order 49.
To the application. Stop. As paid, list after 1 week.
Grateful.
Yes, it does.
Item number 15.
Lordship, after the appellant, Lordship, I'm paying for the mixer.
Why, madam?
Lordship, in
Since
this matter,
yesterday,
for
you
the-
are only seeking adjournment in all the matters. Why?
Lordship, it's a long pending matter, Lordship.
So it
And
should
Mr.
remain pending
No,
for
no,
some more
Lordship,
time.
Lordship, what happened in this that initially it was a matter under section 9 of Hindu Marriage Act, and that eventually order 6 rule 17 it transferred to 13 of the Hindu Marriage Act. Now we challenge one of the order and it's being matter is just pending. And Lordship, in the last circuit there was a reconciliation conducted by this court only, and that was failed. So, Lordship, this matters, and moreover, Lordship, in this matter, Mr. Thomas Mukherjee will appearing from Calcutta, and he has some personal.
And for the respondent.
Sorry, Lordship.
Spread list in the next circuit.
Grateful, Lordship.
Item 16.
For the appellant. But kindly, my lord, fix the matter for next circuit, my lord.
Which you are not interested in.
No, my lord, my learned senior is, my lord, out of station, my lord, due to medical urgency, my lord.
There are tens of adjournments.
My lord, this is last auction, my lord. Kindly, my lord, on next circuit. My lord, kindly, my lord.
What is the valuation
My lord,
of the
no.
subject property?
Shoot. My lord. And I'm not carrying the brief with me, my lord.
Very nice. Why are you here? Come for a stroll in the court or what? There are tens of orders passed. Regarding maintainability, there is no order. Today again, you want an adjournment. You don't know anything about maintainability. What is this, sir?
My lord, on last auction, my lord, I'm paying.
Come tomorrow. Go through it.
My lord.
Okay.
Item number 17.
Kindly put this matter into next week, Your Lordship. The contacting advocate applied for some certified copy to produce before the landed court. The contacting advocate applied for some certified copy to produce before you, Your Lordship. That's why.
Certified copy.
Yes, my Lordship.
For what?
They have instructed me to.
Lordship, kindly fix this matter on Monday, Lordship. Then I'll be prepared with the matter, Lordship.
Send to the mediator. Copy of order. Mediator.
What happened in the mediation?
Lordship, I don't have any idea about it because I'm not dealing with this matter.
Next week.
Yes, my Lordship, Monday, Lordship. Monday, Lordship.
She wants 1 week. Don't have why mediation failed.
Lordship, I need to seek instructions from my client, Lordship.
Because the prayer was rejected by the tribe. There have been a positive mediation. Seek instructions, let it come the next.
Item number 18. My lord, I appear for the respondent husband.
18, Lordship, I'm paying for next circuit, Lordship.
My lord,
Next
paperwork,
circuit,
paperwork.
Lordship.
You're for the husband.
I am for the husband. সবার নাম দিয়ে তো পরের দিন এডজমেন্ট দিতে আসলে আমাদের কখন না না 23 নম্বর আমাদের 19 পেজ
Why are you keeping it pending? Marriage is dissolved, you're not taking any steps. Why it is to be kept pending? For what purpose? There also decree was ex parte. What is the fun in having just this matter pending before the court?
No, Lordship, I'm not the conducting advocate, Lordship. The conducting advocate is not.
Ask him to be here
available.
Thursday.
খবরে দিও আমার ঠিক আছে মন ইচ্ছা হয়েছে
As states matters are granted to that.
Great.
Item number 19.
I think number 19 for the appellant's Lordship. The I'm being led by Advocate Rajiv Kumar Jain from the principal bench. But due to some medical emergencies, he's currently out of Calcutta. He'll be doing the matter. Kindly place the matter before his bench.
Next circuit. My lord, I am representing the respondent number 8. Kindly accommodate in the next circuit.
My lord, I am for respondent number 1.
Great.
Item number 20.
My lord, I am for the respondent. I am being led by Mr. Digantopal and Indranuj Datta.
Ma'am,
I am appealing for the
my
appellant.
lord, I am appealing for the respondent. I beg to appear virtually, my lord.
Wife is the apparent before my lord.
Wife.
Now, my lord, decree, my lord, I would say, my lord, the trial court held that there is a cruelty, but has not passed the decree for divorce, but instead had passed the decree for judicial separation. Now, my lord, my short conspectus of, I'm the plaintiff. Now, my lord, my short conspectus of challenge is after, my lord, court finds, my lord, there is a cruelty. My lord, the decree for judicial separation, my lord, in my respectful humble submission would not be granted. Firstly, my lord, secondly, my lord, the trial court has overlooked, my lord, the cross-examination of the husband, where the husband also deposes that there is no further scope of reconciliation. So, my lord, it is a case where both the parties deposes before the court, one files a suit for divorce and one deposes before the court, that there is no scope of, my lord, coming back to the life. Now, my lord, in that circumstances, my lord, this judicial separation decree, my lord, in my respectful humble submission should not stand. Now, my lord, taking my lord to the relevant paragraph of the impugned judgment, my lord, kindly turns to page 96 of the paper book.
Not be able to conclude this today. And now we have 3 matters. We can start, but there's no way that it can be completed.
My lord, if I may submit a small thing, my lord, this matter can be referred to the mediation because, my lord, I'm saying There is no cruelty. If you kindly take the order, my lord, the judgment passed by the trial court, the trial court has not found any
There is a
evidence
finding
of
of what?
cruelty. There is no finding of
My
evidence
lord,
to
kindly
justify
comes
the
to my
cruelty,
page
my lord.
101.
And my lord, if you
Go
also
on, start from page 90.
also, my lord, kindly if you come to page number 66 and 67 of the paper book, that is the cross examination. That is the cross examination done, my lord. If you kindly come to page number 66, my lord,
101.
my lord has taken
Internal page 6. May I just place the second paragraph? Admittedly, as an
my
apparent on record, my lord. The present couple having a minor son, such and such legal proceeding under section 9 for restitution of conjugal to be more specific for the return of the wife with minor child to his house to lead a family life. Both the spouses are youngsters blessed with a male child. In such backdrop of unique nature, this family dispute between the young spouses should be need be approached with social point of view and social feeling, though there is apparent cruelty on the part of husband towards his wife in not providing minimum maintenance to his wife for his wife with minor child before the institution of this, so despite having adequate means and sound financial capacity, which is good ground to sever the marital tie forever. Now, this is when Milord the court categorically finds cruelty. Thereafter, Milord takes on why judicial separation. Under the Hindu law, marriage is considered a sacrament in Indian culture, and husband and wife are bound in unbreakable bond through rituals and traditions. In a divorce, the marriage is ended forever and the couple cannot get back together. But in a court separation, the couple may try to work things out, contemplate and apply second thought over their relationship, especially in the context of our Indian culture, and get back together to start a life together. In the case in hand, the couple have a minor child born out of their marital tie, and rather it goes without saying that their minor child is a bridge between the two and is the symbol of love, affection, and respect of spouses for each other, especially in our Indian culture. There is a ray of hope which spills light on a chance of reunion of the young spouses of divorce.
my lord, if I may submit one small thing, that if
You're for the wife. I'm for the wife.
My lord, if I may submit one small submission, my lord, kindly come to page number 66 of the paper book, which is the cross examination. My lord, the reason
Meantime,
that
if the separation has been directed, you are facing any problem?
No, no problem, my lord. Because we tried mediation, my lord, in the trial court, it failed. My lord, after this order, my lord, not for a single day the husband has tried to contact me. There is complete severance. And my lord, I support this, my lord, why the deposition of the husband in cross-examination, whereon a suggestion put by my advocate that whether there is a scope of reconciliation, he answers, not a fact, that there is a scope of reconciliation. So, my lord, from his now, from the bar, such submissions coming, but in cross-examination, my learned advocate.
No, we are hearing you. Hearing when we ask him to say, he's unnecessarily making submission. Paying attention.
My lord, it's complete failure. And my lord, on this apparent cruelty, and there is no challenge to this order. Today, my lord, if he says this is wrong, my lord, he has not preferred any challenge to this finding, concrete finding by the court. Not even a cross objection. And my lord knows under judicial separation, if the spouses don't reunite for 2 years, then decree for divorce is automatic on a mere application.
That is what we were saying. We were discussing. Then why do you want to challenge it? If you know that there is no.
But my 2 years will go. Let 2 years
That's
will
why
go.
we asked you, is there any problem?
Problem, I can restart a new life. But today, my lord, with this, my lord, hanging on my head.
And what about your maintenance and all that?
My lord, that I can take instruction, my lord, I can forego, my lord, as per, my lord, what I have seen to my client, I can make her apprise that you forego this because you want to start a new life. Though she has prayed for permanent alimony, but I will definitely speak to her on that.
The court has considered the practical circumstance that both parties are relatively not of very advanced age. They are young people having a minor child. The scope of reconciliation remains if there is a judicial separation. It's a big issue. And we are trying to ascertain that the petitioner appellant wants immediate severance. Why?
Because there is no mental match. We got two brains, which has severed so hard that one cannot force this matrimonial.
How long ago the marriage was?
2021. Since 2021, they're living apart. Now we are in 26.
Almost 21 and separation in 21.
21, admittedly. So there is no scope meeting of minds. They have moved ahead, much ahead.
And where is the child?
Child is with the mother, happy. And the father has never met with the child. And that's the finding when the child was born. The father has himself deposed, I don't know anything about the child. Because he has never bothered to inquire.
Where they are living?
Kolkata, no? In Calcutta. Present. Because that matrimonial place of residence was within this circuit, Jalpaiguri. Jurisdiction of.
Are in Calcutta.
No, my lord, he was in Jalpai. Husband the husband is in Shri. Matrimonial home is also Shri.
Yes. Yes, what do you want to say?
My lord, the reason that learned trial court held that there is an apparent cruelty is because, my lord, if you kindly come to page number 66 and 67 of the paper book, which is the cross-examination held, your lordship there.
What do you want out of the proceedings? What
My
does
lord,
your client want out of this proceeding?
my lord, right now we want to go to the mediation because of two reasons primarily. First, my lord, there is this child of 13 years, minor child, whom I have not been able to meet
13
because
years?
of the. Yes, your lord. Yes, lordship. The child was born on 2013. 16 years, my lord.
You said
2013. He was.
21. No, separation 21. Child.
It's a minor child, my lord.
When the marriage was solemnized.
Oh, marriage was solemnized.
Marriage was solemnized in 9, my lord. 2009. 2009.
2nd of December 2009.
2nd December 2009.
Therefore, the differences occurred much later.
Yes.
Yes,
Differences
my lord.
occurred, my lord, after 5,
13,
6
14
years started.
years. No, 13, 14 years.
No, my lord. Now 13, 14 years suit has gone, my lord. This has drawn up, my lord.
My lord.
But my lord, the difference started, my lord. Before first hand there was a miscarriage, allegation started. My lord, this is the second time, my lord, the child was born. My lord, there are counter allegations on the part of the husband. My lord, I allege, my lord, he is a drunkard. He admits, my lord, he drinks. And in the, my lord, one of the grounds of adjournment, my lord, will find he is in rehabilitation center. My lord, these are on record. Though court has gone to the fact, my lord, has held cruelty because he has deposed even that I did not care about the child, did not pay anything.
So he is not earning.
He's earning. He is in HDFC Bank. That is his categorical statement at that point of time in a managerial post, earning 70,000 odd in a month. And he paid nothing to the wife. Left the wife in
My lord.
destitute condition.
My lord, if I must submit, my lord, if I must submit the reason which learned court held apparent cruelty because the appellant has not been able to prove any evidence with respect to this cruelty. Neither the landlord where we had taken a rent had deposed that there was any cruelty, not friends and family. Also, my lord, my client has been giving the maintenance of rupees 30,000 per month plus along with 5,000 areas.
What do you
every
want from
month.
the proceeding? We are asking you, what do you want from
My
the
lord,
proceeding? You have not challenged the order.
No, my lord, kindly refer this matter to mediation. If the mediation fails, then this appeal is always there for adjudication before this honorable court.
What
So that's the
mediation?
only-
What will you do?
My lord,
What
my
do you
lord,
want
I,
to do? What is your
my lord, I am always ready. My lord, right now I'm ready to take on the child along with the mother, and when I want to live a happy married life. That's the reason. That's the only reason I'm praying for a mediation. Because also, my lord, if you kindly, my lord, come to page 39, my lord, of the paper book, you will see,
Don't
my
say
lord.
mediation and this page, that page at the same time. Mediation means mediation.
Yes, my lord. Yes, my lord.
Don't
Yes,
go to
I-
pages. Therefore, we ask you, what do you want?
My lord, the only mediation. Kindly refer this to mediation. If the mediation fails, then the appeal is always there.
Why don't you try for a rapprochement?
Milord, mediation was tried, Milord, in the trial court for quite some time, but it failed. It failed. Milord, I have spoken before moving the matter where there is any
Is
chance
it
of
possible for the wife to come?
Milord, she is no more in a position to come back because she says, Milord, I have moved much ahead in life. It's only that this judicial separation, instead of waiting for 2 years, this can be cut short when on both ends. Milord, though these submissions are coming, that's why I say, Milord, this would be the submission, but in cross-examination, other things are being said.
No, but then things move on. Maybe at that point of time, there was a different frame of mind. Today, he's in a different frame of mind. He's rehabilitated, he is more in senses. We don't know. Without going into the details, from whatever we are gathering from submission, if that is the situation, therefore we say, if you meet him, if you see a change of heart, maybe there is a scope. If you don't see, you can proceed. Therefore, we are saying.
Milord, as per in my chamber, Milord, the client has spoken no scope, but my lord can have a Milord conversation with the wife.
That's why we said, how do we do that? If she cannot come, then we can't do that.
She has to come down one day, Milord, in Jalpaiguri.
You have to arrange for her to come.
My lord, I can arrange for the husband to come before your lordship.
No, you have to arrange for her to come. A husband will have to come if he wants mediation. What do you mean arrange?
My lord,
You have to arrange for her to come.
Yes, my lord, I can arrange for her also. my
Arrange
lord.
for
I'm
her
ready
to
do.
comfortably come and then spend a day here.
Yes, my
And
lord,
then she can
definitely.
go back.
Yes, my lord. Yes, my lord. We are ready to do that.
My lord,
We are ready to-
definitely, but
Let's
in my
see,
chamber, she
let's
has
see.
openly said that there is no scope. And the child has now 15 years.
No,
much
then we don't
intelligible
want to
mind.
direct unnecessarily. We think that you should speak to her. This is what is forthcoming. He is willing to arrange a comfortable visit. If she can come for a day to court Monday, Thursday, Friday, any day in the next week, then we can make an attempt.
Then Milord, my lord fixes any day, Milord, I will inform her to buy tickets and come.
No, she is willing to come, or
Milord, my counterpart, he was just messaging that to take instructions. So Milord, he says she will come.
Okay. So then, which day is more convenient for her? Ask her. Monday,
Can he give
Thursday,
a call
Friday.
outside the court?
Please.
I will buy the phone.
Monday, Thursday, Friday, any day. Wait. The son must be in a school. So there's someone to take care of the son there.
Yes. I have spoken very matured mind, Milord.
No, we can proceed on merit. Let us see if there is. Tickets are easily available to come.
The tickets are a bit high priced, but available.
For the, before the war, my lord, it was 2,000, 3,500. Now it's 8,000, 9,000. Season war এর জন্য fuel surcharge সবই তো হয়। What fell from my lord, I was saying to my client that wait for 2 years, it will automatically fall down. She wants to move ahead.
Understand her anguish, but let's see if there is a chance this child will suffer in the past.
She has never met the child. Child doesn't know, my
So
lord.
let's
At
see.
least
See
15
that if
years.
he has any positive vibes now, she will realize.
Yes.
What you and I can't see, she will perceive. If not, she will be reluctant. Then we proceed. Let us see. Maybe he's genuinely changed, given up drinking, whatever you say. We don't know.
That also, my lord, 2021 living separately, wife will not be able to say whether he's continuing drinking or not. But
No,
yeah,
the profile will change. The man's profile will change. It will be perceptible to someone who has seen him in that state, if he was ever in that state. You can fix it. Instead of waiting, make just come back and please be online at 2 p.m. They are coming back with instructions.
My lord, my lord. My request.
Mr. Chatterjee.
Oh, yes. It will come on the list tomorrow. Pass on. No, not at this. Sorry. Yes. With a view to an attempt for rapprochement and amicable settlement, we adjourn the matter to be taken up at 2 p.m. Stop. We are informed, the learned advocate for the appellant of
My lord, if I may submit one thing, my lord.
yes.
My lord, I just got instruction that we are ready for the mediation, but since the respondent is already paying 35,000 per month to the appellant, my lord, it will be, if the lordship is kind enough to forego the transportation and staying of the appellant for this meeting, my lord. This is the only humble submission I am making. We are ready for the mediation, but kindly forego the expenses of for the appellant because we are already paying 35,000 every month. And my lord, also we
She
are
is
ready
coming on, she is coming on her own.
Okay,
That's
my
clear
lord.
the position, my lord. She knew that this would come. That was she.
Yes. You be present. To
Yes,
be
my lord.
present in the
And
court.
yes, my lord.
Yes.
And my respondent is working in the bank, so he'll be able to take a leave on next Friday, my lord. He'll be able to come and appear before your lordship on next Friday, my lord.
Huh?
My lord, he has to take leave from his office since he's working in the bank, my lord. So he has taken his.
You have not spoken to him beforehand.
No.
My lord,
My lord,
my lord.
The husband, my lord, is in Siliguri. My lord, she is coming all the way from Calcutta, my lord. She has said Monday, my lord, she will come down at 2
p.m. whether he can leave the bank.
My lord, kindly appreciate this fact
then
that
may I
the
suggest
We have heard you want Friday. Just wait. We have heard you want it on Friday. Yes.
My lord.
My lord, then may I suggest one thing, my lord? Then kindly keeps it on. Then it will be next circuit. I wish to have it done it because the issue is very small. My lord can hear the wife because under the provision, even if one cannot force in judicial separation to go back. So even she stays for 2 years, my lord, nothing will benefit. It's only that the opinion of the mind, my lord, is wanted to hear that, and my lord, if my lord can persuade my lord, then it's not one-handed. So
But in his absence, the exercise will be futile.
can he be present virtually? At least the mind can be expressed.
No, it's not that will not serve a purpose unless he is here in court. It will be futile exercise. Unless they are face to face, it will not be possible.
Then my lord, let husband order may be recorded on that day. What the wife expresses his mind. Let husband express her mind on Thursday. If my lord feels there is any chance,
No, if they don't sit together, it will not be
it
possible.
will not be possible. I leave it open to my lord whenever my lord wants.
Then when will she be able to come on Friday?
She has to come. It's my court's order.
Yes, sir. Friday at 2 p.m.
Yes, sir. Yes, my lord. Yes, my lord. Yes, my lord.
Instead of Monday, Friday. Give the date of Friday. Don't give Monday, Friday. Give the date at 2 p.m. 7 Oh, 2 p.m. Friday 17. Second half you can have this. Yes. Friday 2 p.m. 1 p.m. Make it 1 p.m. 1 o'clock. 1. Yes.
My lord. My lord.
Friday 1 p.m.
Friday 1 p.m.
Item number 6.
Item number 6, I am appearing for WBSDDCL. Yesterday, your lordship has heard this matter elaborately.
Yes, you were trying to show some. Yes, what do you want?
Lordship, I would like to. Sabyasachi Bhattacharya.
5087.
Yes, ma'am. Lordship,
Oh, this
not
is different.
508,
Not
538. Lordship, if your lordship see that para 12, Honorable Justice has held that the amount fixed by the board was fixed arbitrarily and without disclosing any methodology. Lordship, then again at para 50, Lordship, Justice has also held that option of relegating such matters to compensation to a civil court would, considering the sorry plight of the victims' dependents, would involve much time and resources which the applicants cannot afford to spend. Lordship, our case is also similar because that the deceased was
So that he has agreed that whatever is there in the policy, they will pay.
Lordship, now kindly indulge me to your Lordship, paragraph 18.
Yeah.
Which says that distribution licenses for the time being, as in like no proper guideline being, shall assess the compensation payable on a case-to-case basis, but on a uniform yardstick by resorting to a multiplier akin to the provisions of the Motor Vehicles Act. Lordship, now may I be allowed to present?
Yes.
Now the yardstick of the multiplier method, that is the Motor Vehicles Act, was also laid down in by the Supreme Court in this case of Jalpaiguri.
Yes, yes, that we know, that is Motor Vehicles Act. That we know.
Lordship, so Honorable Justice Sachi has directed that in the absence of any regulation with respect to compensation, courts must rely on the yardstick of multiplier method as laid down in the Motor Vehicles Act. Lordship, upon calculation of a rough calculation of compensation based on the monthly income of the deceased, aggregates to 80 lakhs.
You are addressing the Honorable Judge by first name.
I'm so sorry.
You should be very sorry. Yes.
Sorry.
Yes, proceed.
Lordship, on calculation, on a very rough calculation, it estimates to 80 lakhs reduction based on the method of multiplication, multiplier method.
No, we know, everybody must be aware of the multiplier method. So this judgment of Kavita Mandal, has it been given effect to? Yes, who is for your appearing? What is your instruction? Has this judgment been complied? No, it's not mute. Oh yes, it is mute. Unmute him.
Unmute.
Yes, has this judgment been implemented?
So far the Kavita Mandal is concerned, your lordship will find, here it has been specified, I have given the division bench judgment. So far the, here if your lordship kindly see the paragraph 3, here the policy has been adopted, lordship. 5 lakh rupees policy
Again,
has
we
been
are
adopted.
asking you, has this judgment been implemented?
I have to take instruction on that issue.
Then tell us, don't make submissions.
I am not aware because just now, yes.
So
submitted,
tell us, why are you to distinguish your case?
Yes.
Where is the question of distinguishing? If you
No,
are
no,
applying
no.
the multiplier, you have to multiply for everyone, apply it for
No, no.
everyone. Yes.
No, I have to take instruction
Judgment
on this issue.
of the a judgment of the
But so far the
coordinate
Kavita
bench.
Mandal is concerned. Yes,
In the
lordship.
judgment
But
of the
division
Honorable
bench has
Civil
already
Judge,
held.
the case of Kavita Mandal passed in WPA 23672 of 2015.
May
is
I
relied
submit,
upon by
lordship, may I,
learned.
the appeal has been preferred against this order. Appeal has been preferred against this order. This
So
appeal.
that is what we are asking you. Yes.
Yes.
Then tell us.
I have already placed that order. I have already placed that order before your lordship. It is
Oh, that
MAT
order you have
735
placed.
of 2022. Yes, and that has been
MAT?
stayed. That has been, yes, MAT 735 of 2022, lordship. Probably it has been handed over to your lordship.
Yesterday.
Yesterday it has been handed over. That's why I'm saying that that multiplier has been given, but the court has stayed this order, division bench.
735.
No, he's saying 75.
Oh, no, 735.
Mat 735 of 2000.
Oh, 735.
Lordship.
This is arising
Lordship.
out of, oh, yes, Kavita Mandal.
Yes, Kavita Mandal. Kindly see. This policy has been adopted by the division bench also, by this bench also in the Raju Sheikh, in the division bench, it has been adopted. And so far, this adoption is concerned, 5 lakh compensation has been granted. And if they have got any other relief, in Raju Sheikh case, it has been held that he can file a civil suit. Kindly see the division bench judgment. It has already been stayed. My learned friend is placing one order which has already been stayed by the division bench. I'm sorry, I couldn't get that. That's why. Lordship got that?
Yes, yes, we are looking at it.
Because I cannot visualize that. That's why I'm sorry for that. Para 3, para 4, para 5. 7.
So you pay the 5 lakh rupees, then it will be,
Yes, yes.
his case will be
Since
considered
it has
after
fallen-
or along.
Since
His
it has
case will
fallen
be
from your
considered
lordship-
for anything else, it will be considered after the disposal of MAT 735.
As your lordship, please. As your lordship, please.
Yes.
Because I'm sorry, I couldn't got that. That's why I couldn't place before your lordship.
The writ petitioner is wife of an individual who died due to electrocution. A claim for compensation was made before the writ court. Stop. The Honorable Single Judge dismissed the writ petition by the judgment dated 1/9/2025, passed in the writ petition hearing WPA number 1727 of 2025. Full stop. The order of the Honorable Single Judge is the subject matter of the present intra-court appeal. The brief factual background as per averments made in the writ petition is that at around 12 noon on 11/3/25, the writ petitioner's husband died due to electrocution. Stop. Alleging that the death
Lordship, I cannot hear. Your voice is not coming, Lordship.
You are also for the company.
I'm for the double.
Item number 9. This matter. Respondent to file their reply.
Oh,
Yes, applied as the copy a while back. Kindly not argue the matter tomorrow.
Is appearing in Bhatpuri, does it kindly?
No, I'm just asking it to be.
he wants it tomorrow.
Also, Mr. Rai is also engaged.
No, don't worry about him. You may start if you want.
I just want to go through the reply.
So if you want the time, you say so. What is to be argued? Go and appear there.
But still, my lord, I want to be clear to my conscience that I have read everything.
All right, you let him be here.
Especially the matter fix on tomorrow 2 p.m.
As the court feels. Up to the court, 2, 1, 10, whatever.
No, tomorrow it cannot be at 2 p.m. Tomorrow this bench-
I have
most probably this bench, division bench will not be available after 1 p.m.
So, my lord, whenever your lordship desire, I will be here from 10:30 on.
We can fix it at 12. At 12 noon,
Right,
if you,
I will- I will be
it can be disposed of, otherwise we'll fix it in the next week. If it
As you-
requires elaborate hearing, then it can't be done tomorrow.
So, my lord, at
12 noon. Fix a time, 12 noon.
Item number 13.
I am for the respondent bank, beg to submit lordship. Sometime back today, the bank informed me that they have deposited entire rent along with 50% enhanced rent in the account. So I say, I beg to submit that in this case, I shall file the statement account along with clarification on Monday.
Already paid them not.
My lord, I have not received any such communication from the
Didn't
plaintiff.
tell him.
No, sometime back I received.
Should have told him, he could have taken instructions. If the entire amount is deposited, then what will remain?
My lord, the date would be vital, my lord. Till what date they have calculated and deposited.
That's why we said, if you had the details, we don't know what would remain.
Exactly.
On Monday, if lordship fix this.
My lord,
case,
my difficulty would be, my lord, just now the advocate who is conducting, my lord, he is not in Siliguri. He's not in Siliguri, he is gone to with his family for a vacation. He'll be returning only by Tuesday, my lord.
If it's on Thursday, if it is on.
Till on Thursday.
We are informed by the learned representing the respondent bank that he has instructions to submit that the entire areas with enhancement due was already paid to the plaintiff appellant.
My lord, 21, I'm for the appeal. My lord, though paper books have been exchanged, my lord, that entire to hear this appeal, my lord, nothing is required, my lord, because the appeal court, the trial court has miserably failed and passed a decree and assumed jurisdiction which is barred by law, my lord. My only question here is, my lord, the decree was passed under Hindu Marriage Act, my lord, for divorce by the trial court, my lord, while both the appellant and the respondent are members of scheduled tribes, admittedly. And my lord, in view of section 2, subsection 2 of Hindu Marriage Act, my lord, there is a specific bar that no such this act is not applicable to the members of STSC Act, scheduled tribes and scheduled castes. And there is a judgment of the Honorable Supreme Court which affirms the same.
On behalf of the respondent, Mr. Counsel, Mr. Vedanta Kaushik is appearing. He's from Guwahati, and today is date fixed for poll in Assam, my lord. I've talked with him. Earlier occasion, he also appeared and represented. I think next week any day, my lord.
He has raised a issue regarding the jurisdiction of the court, trial court.
My lord, I am not briefing this matter. My lord, my colleague brother, senior, my lord, he is appearing, he is representing his case. He requested me, kindly post next week. My lord, today is date fixed for.
We are requesting you to communicate something.
Yes, my
It can't be a one-way thing.
My lord, my lord.
Has to be operate both ways.
My lord, my lord.
So he has raised an issue regarding maintainability of the proceeding under the Hindu Marriage Act, relying on section 2, subsection 2, because the parties are scheduled castes, therefore the
Scheduled
act will
tribes.
not right. Therefore the act will not apply. So if we don't know, subject to what you may say, if you will raise this issue that day, if you are taken by surprise, so we are letting you know.
My lord, I can understand.
Is whether an ST would be covered
By the
whether
act
court-
or
if there is a inherent lack of jurisdiction, then what remains?
my lord.
Just communicate this.
My lord.
When she will come? Who is
No, next week. Any day. Monday.
Straight by the learned advocate representing the respondent. Monday.
Item number 22.
It is hard. It is hard.
All the next.
My lord, in this matter, I am for the appellant. But yesterday I told that it may be taken up on Thursday, but other side lawyer, she says that it will be better, it will be taken up on Monday. Monday. I would be ready. Monday.
As prayed, list on Monday का date.
Grateful, Lordship.
Item number 24.
So I'm for the petitioner. Paper book is not ready, Lordship.
Not ready.
Kindly fix it in next circuit. And two respondent also died, and services are also not completed.
Next steps.
Lordship.
That he will be taking steps.
Item number 25, my lord, I appear on behalf of the appellant.
Yes. Item number 25.
Item number 25 laid by senior counsel, your lordships, and online or in number.
I appear on behalf of the appellant, my lord, in this matter. This is really, my lord, a matter in which, my lord, the plaint has been rejected, my lord, by the first court under Order 7, Rule 11. And now, my lord, we have filed, my lord, this appeal challenging, my lord, the rejection of the plaint. Now, in the meantime, there was the question of impediment, my lord, of the purchaser pendentility. This is a suit for specific performance of contract. Purchaser pendentility has already been impleted by an earlier order. There's another application which is CAN 6, which appears to be on board, where another party has sought to be impleted in the present appeal, though not being impleted in the suit. Now, subject to that application being heard out, Lord, the matter would otherwise be ready for hearing. I was beseeching if your lordship kindly takes up, Lord, the application of that third party.
Who is representing it?
Lordships, two senior counsel and from Siliguri, Ashish. In Siliguri, one counsel, Ashish Sinha, and other counsel from other side. I will intimate your lordships by notice.
But it is not present.
Siliguri, from Siliguri, Ashish Sinha. I know him, your lordships. I will intimate by notice, your lordships. Or
If he is there to, my lord, press his prayer for addition, then
No, he is not here.
My lords can pass. Orders.
He is not
He
here.
isn't, my
He
lord,
is
then
not
the
here.
application should go, and then the main application can be heard out. Oh, I see. I see. I see.
He is saying he will intimate. He knows the learned advocate. So let him inform.
Fair enough. Then, my lord, we can come back, my lord, a week hence if your lordship so directs.
A week.
A week, or maybe next circuit, whichever way, Lord, whichever comments to your lordship, because he will have to be heard. Otherwise,
Learned
that
advocate, Mr. So-and-so submits that he will intimate the learned advocate representing the applicant
Item number 26.
My lord has, sorry, my lord has kept it, my lord, after a week or next second, I could not hear that part.
Next
my lord,
circuit, next circuit. Next circuit.
Next circuit. Obliged, lord. Obliged, lord.
No, sir. 27.
Yeah, please, your lordship. Yesterday, today's stake is present.
My lord,
I'll
the
just
permit-
need the confirmation report from for 390 has been already confirmed or not. Nothing
Actually,
else.
London FPP will appear in this case, but the conference with LR is busy in meeting with LR.
Lordship,
LR is
only a
present before you.
report can be come out and put it to be next circuit. He is for the state, Lordship.
What report are you asking?
Lordship, kindly come to page number 163.
What is it? Tell us.
This is a appeal against acquittal.
What is the report that you want?
Lordship, with a month from the receipt of notice, opposite party number 1 to 11 shall appear before the learned trial court, and upon their appearance, they shall be released on bail. This is the as per section 3.
Yes, yesterday we were asking.
Lordship, this is the 390.
So just find out what is going on.
My lord. A 2-line order may suffice, Lordship, kindly. Confirmation of 390 has whether has been complied or not. That's the only thing I'm.
Is 131.
163.
163 page.
At the time of admission of the appeal, the then Mr. Jaimallo Bagchi, Justice Jaimallo Bagchi was passed this order.
Within a month from the receipt to the notice of the court.
ওটা অ্যাপিয়ার করে বেল নিয়েছে কিনা
এই রিপোর্টটা লাগবে।
দ্যাটস অল।
The learned advocate representing the appellant submits that
Item number 28.
For the appellant.
29.
My lord, in item number 29, I am representing the appellant. As per order, as per last order, I have served the notice upon the respondent.
Oh, thank you.
you have filed an affidavit.
Practically, till now that report that they whether they have received the notice or not, confirmation has not been made. Okay, I'll
So
file
it
the
is.
affidavit. My
So
lord,
service is incomplete.
service is incomplete, my lord. Monday,
Yes,
Monday, kindly fix it Monday, my lord.
Submitted by learned advocate for the appellant that service is incomplete. Full stop. He seeks adjournment of the matter for filing an affidavit of service.
My lord. Kindly fix it Monday, my lord.
Not today. 29. Item number 30. 31. 32,
Lordship, not today. 32.
33,
Lordship, praying for one day accommodation.
yes,
Grateful.
34,
Lordship, I'm praying for, kindly keep this matter on Thursday, Lordship. Because one matter was item number 2, 2 was fixed on Monday. So we'll do the matter on Thursday, Lordship. 1302 matter.
You are for the appellant.
Yes, the Lordship.
See tomorrow what is the position.
35,
Grateful, Lordship.
36 and 37, 38, 39, 40, 41, 42, 43, 44, 45, 46, 47, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57, 58, 59.
Requesting for next circuit.
Circuit.
It's a long hearing matter, Lordship.
As per list in the next.
59. 59.
Both sides are present.
Yes,
My
it's
lord,
a state. Mr. Chakraborty will appear.
Your
Lord.
appearance.
My lord.
60, 61, 62, 63,
Next circuit, Lordship. 63.
Yes.
63 of the division, 4 June.
64 and 65, 66, 67, 68, 69,
Next circuit, 69.
Yes.
70, 71, 72, 73, 74, 75, 76,
76, I am for the
77.
respondent, my lord. 76.
Yes. Next.
In 76.
77, 78,
Next circuit.
79 and 80, 81, 82, 83, 84, 85, 86, 87, $88,
Lordship, praying for next circuit.
What is it?
87, 88.
88.
What is it?
Actually, Lordship, the advocate on record is currently unavailable. Lordship, I don't have the brief. I just received instructions right now.
Criminal appeal, is it criminal appeal? Criminal appeal.
Yes, Your Lordship.
Criminal appeal.
I'm not the advocate on record. I just received the instruction a minute ago.
Criminal appeal. Yes. This for the state.
Mr. Chakraborty.
In 88.
80.
That's great.
Grateful, Your Lordships.
No.
87 and 88.
Yes, 87 and 88 are together. My senior is, he's representing 88.
No, then we'll not. Tomorrow we'll see.
Okay, tomorrow.
89,
Okay.
90, 91, 92, 93, 94, 95, 96, 97, 98, 99, 100, 101 to 110, 111 to 120.
111, 112, kindly fix it next circuit, my lord.
You are for the appellant.
No, myself is for the respondent, DRI, Union of India. Revenue Intelligence.
Sorry.
121 to 130. 131 to 140. 141 to 150. 151 to 160.
Lordship, 154 and along with 155. Kindly be next circuit.
You are for the.
Appellant.
In both the cases.
Yes. Now, one is Binod Thapa where it's filed, it's for the jail appeal, and the another one for appeal
এই
filed. by
আওয়াজটা কেন
the-
করছো?
You are not appearing. Huh? You saying something?
What is this? Item 154 and 155.
No, if you are not appearing in both, then we'll not.
Both the matters I'm appearing.
In 155 also.
Yes, yes.
All right. Next circle. Give your appearance in both.
Yes, yes, Marshal. Grateful. One is jail appeal, one is appeal filed by the authority.
161 to 170. 171 to 180. 181 to 183.